teeth, so that indeed he could be gagged, and I will use that word because that is what we want. We are stating that we can so bring the motion, so it's admissible. Article 177 is not only subject to the Constitution, Mr. Speaker. Let me read it again so that the Speaker, the Honorable Attorney General, listen. Subject to the provisions of this Constitution and the rules of procedure of this National Assembly. And that's what? It's so clear. It is subject to the rules of this National Assembly. And we want to make it clear, Mr. Speaker, that if today we do not ensure that this National Assembly has inherent in it all these powers, we are going to denude this National Assembly of that which makes it of such majesty. We are going to, in a sense, dilute and water down, neuter it to the extent that it will have no power, and especially with a majority in the opposition, no power to do anything. And so we have a scenario whereby to shut this motion out when the Constitution provides for it is clearly something that you ought not to rule in favor of the Attorney General. He talks about the privilege that his Honorable Home Affairs Minister has to speak. But this is in collision course, Mr. Speaker, with the command of this National Assembly by a majority resolution. I understand, and I want to state that indeed it is new ground, it is new territory, it is new seas that we are chartering herein. But it must be understood then that when we, in a sense, distill what we have before us, it is the privilege of the Honorable Minister as against the command of this National Assembly. And we are stating, by virtue of what we are in the limited way talking about, we can restrict Mr. Rohee as Honorable Minister of Home Affairs from speaking. Because of that, no confidence. We are not in any way indicating, and we have made that quite clear. We made it quite clear. And so the concept of what is called, and to answer your question, yes. We wanted to indicate that this, to your question, that this due process is, we are not abusing his due process here, Mr. Speaker.
You mentioned a privilege versus a command.
That's right.
So you recognize a privilege?
I recognize the privilege, but that command is also a privilege.
Agreed. So that is where my question about due process comes in. The removing or the vacating of that privilege, what is that? Is it by a command?
It is, and I urge this
is the privilege holder right of hearing or...
Once it's a motion brought that we can, and it is passed by a majority, just like what happened in Jagan and Gatraj, he has to abide by it. And he went to court. The two Jagans then, Derek and Chenny Jagan, famous men, one speaker here, they went to court for an injunction. And the court ruled them out of place. That inside of this assembly, go and get your remedy. Don't come to the court. And this is 1965. And only the other day, in relation to the Committee of Selection, my learned friend run to the court again and say that this National Assembly is wrong. And what did the Chief Justice rule? The Chief Justice ruled that his entire application and motion, whatever it was misconceived and flawed. Let me just read what Mr. Chan said about it. Let me read slowly. a minister wanting to act in conventions, or any member for that matter, and then being disobedient and defiant in the face of conventions, you bring to a crisis level the National Assembly. It creates disharmony and rancor. And that is why conventions came, so that you can get the business of the House going along pretty nicely by the minister removing himself. But you have now created a logjam, a confrontation, and you're saying that it is the majority. No! That is why it was regarded as a lubricant by a famous politician that I was quoting there, a famous politician of England, I can't remember his name, but he said it was the lubricant that ensures the machinery works. It doesn't have to be written anywhere. It is a convention, and the majority of the House have no confidence in you. We want confrontation, and that is what we're ending up here. And we got to debate, and we got to deliberate, and we got to pass down each other, and whatever it is. And so, Mr. Speaker, the members over there obviously do not understand the underpinnings of convention. And the underpinnings and the philosophical rationale behind it, that please go. The majority of the House do not want to. And it's in that context, because just like Mr. Jagan, Dr. Jagan and his brother, when they defied the House Speaker then asked for a motion and they suspended them. Exactly what we are doing here. He wants to speak. And I am saying in that context then, we can come to this motion to ensure that that defiance is brought to a halt. And so that we are entitled to do just that. This is very much something that is very much admissible. I want to just, in ending, indicate that our Steinmay Parliamentary Practice, the 21st edition, at page 326, yeah, it's a very expensive book, but it is my book. Matters awaiting judicial decision. Matters awaiting judicial decision. The House has resolved that matters awaiting adjudication by a court of law should not be brought before it by motion or otherwise. And then they go on to say, this rule, however, may be waived at the discretion of the chair. Exceptions have, for example, been made on matters before the civil courts which relate to ministerial decisions concerning issues of national importance, matters which have no likelihood of coming up before the courts in a reasonable foreseeable future. Listen to that. Matters which have no likelihood of coming before the courts in the reasonable foreseeable future, and so on. We know that you got here. We're not defeating the argument. We are saying that the discretion of the chair, and if you didn't listen to me, Mr. Nandi, we are indicating, yes, and we are saying it to be waived. It could be waived. And matters which, though touching upon issues which are sub judice, are unlikely to be affecting the judge's judgment. I want to bring this point. Mr. Chang is not going to be in any way prejudiced by what we say here. He's Chief Justice, and just like Chief Justice Lahu did, he might very well say to that motion that it is entertainable in this Parliament, and he can very well have that it is again another misconceived motion. Just like a committee of selection motion. Let him say so. Yes. Additionally, we have a number of instances at page 378 where successive speakers have exercised their discretion to allow matters to be discussed. notwithstanding them being in the courts of law in England. Because, of course, on one round, they have considered that no substantial risk of prejudicing the proceedings would arise. Mr. Speaker, as I have indicated in my preamble point here, that government over there can block everything that the opposition would like to do. That is what they want to do by bringing this sub judice rule or that adjudicating of matters before the court. And if I may say so, I want to believe that indeed that was the reason why it was brought. Because it was, and as said by a senior counsel, it was a sham. Mr. Speaker, our Stelmate 21st edition has a number of classic examples where this sub judice rule, or that which my learned friend is talking about, as to making this motion inadmissible, where our Stelmate's examples can apply to waive it. He didn't say anything about our Stelmate, I noticed. But we must bring the total picture to this house. We must not indicate that, you know, oh, there it is. There is a standing order that says so, and then literally defeat that argument by saying that standing orders are not law. And then want to quote the standing order to get the whole parliament. I can't understand that. Mr. Speaker, this motion is very much admissible, and I wish that you so rule as regards. Thank you very much.